welcome back after lunch. My name's Katrina. If you could all take your seat, we're going to start the afternoon session. Thank you. While you're sitting down, my name is Katrina. I'm the Programme Director for the Masters in International and Comparative Disability Law here in the Centre. And if any of you are interested in a Masters programme, very unique educational programme, you'll find the information about it in the back of your book. And I encourage you to have a look at that and come and talk to me if anyone's interested in it. So today I have the honour of introducing our first panel. So just as a reminder, today is about international solidarity and human rights monitoring to protect family life. Earlier this morning you looked at the international treaty bodies and members of both the CRC and CRPD committee. And this afternoon we're moving on to look at national human rights institutions and their role in monitoring compliance with the CRPD and with UN conventions. So we have three people speaking on the panel, all from different countries. We have Ireland, Kenya, and from Germany. I'll introduce each of them as they come up to speak to you, but each are from national human rights institutions within their own countries. So first up to speak to you is Elliott from Ireland. She joined the Irish Human Rights and Equality Commission as Head of Policy and Research in March 2018, and she's taken the lead on the work in monitoring CRPD compliance. And she's going to talk to you about the role of the Irish National Human Rights Commission in relation to protecting the right to family life. So I'm going to hand you over to her.
Thanks very much. I'm delighted to be here today. I can't believe this is the 11th Disability Summary School, because since it was initiated, I've wanted to come every year, so it's taken me 11 years to come here. I'm also really delighted to be on a panel with colleagues from Kenya and Germany. I know the theme of this conference is around our family, and certainly as a member of the National Human Rights Institution and the National Equality Body, you know, these are members of my family. And when Ireland became the last European member state to ratify CRPD and still not ratified the optional protocol, we very much reached out to our colleagues in the National Human Rights Institutions in Europe and globally for their advice, and I'm really delighted to recognise particularly Valentin was so incredibly helpful and generous with the experience in Germany, as many others were. And I think that's really important to have a sense of how national human rights institutions work within our own state, but also are part of a very strong, vibrant and committed international network as well. So Ireland is IREC, the Irish Human Rights and Equality Commission, are a member of the European Network of National Human Rights Institutions. We currently have the chair, so I know the invitation was extended to our Chief Commissioner, Emily Logan, but she's actually in New York today as the chair of ENRI, meeting as part of the Global Alliance of National Human Rights Institutions. So I think no more than we're talking about social movements, I think then an element of social movements and an element of the architecture around disability rights and the right to family life is this network of national human rights institutions. So in terms of what I want to cover today, I want to talk a little bit about the Commission. I'm really delighted we have a Commission member in the room, Frank Connaughton, who is the Vice Chair of our Disability Advisory Committee, and also my colleague Barry Price from the Executive is here, and Barry works very closely with the Disability Advisory Committee. So if you're interested in some of the things that we talk about today, there's three of us essentially in the room if you want to sort of follow up with us today. I'm then going to talk a little bit about some of the work that the Commission has done around bringing family rights home. And on World Refugee Day, I'm going to talk about some of our casework around family reunification and right to remain from our legal casework side, which illustrates how national human rights institutions can engage with the right to family life. And I'm also going to talk a little bit about our work around policy and legislation. Because this is obviously the Disability Summer School, I'm going to also just introduce you to some of the work that we're doing around disability in the Commission. And then I just want to finish with some reflections on where I feel like there is solidarity and shared learning and activism between the disability movement and the LGBTQI movement. And some of that is based on the work that we do in IREC, but also some of the work that I've done myself in my own research. I did some pro bono research for both marriage equality in Ireland and also for Here NI in Northern Ireland around the rights to family life of families which are parented by lesbian and gay and bisexual parents. So I have a sense of some of the shared common ground there. And also when I used to work in the National Disability Authority, I commissioned a piece of work around sexual orientation and disability. And that's going back probably to about 2004. So this is a long conversation, I think, in terms of where there's common ground and shared identity around our social movements. So to talk a bit about the Commission itself, as I said, we're the National Human Rights Institution and we're also the national equality body. We've been in existence since 2014, and it was the bringing together of the Equality Authority and the Irish Human Rights Commission that created IREC. It's a Class A National Human Rights institution, so we're an independent public body. We report to the Oireachtas. Our funding comes through the approval of the Oireachtas or Irish Parliament. And so we are very much a strong independent voice around disability rights. We have 15 publicly recruited members, and they're appointed by our Head of State, President Michael D. Higgins. We have a full-time Chief Commissioner, Emily Logan, as well as then the other Commission members. And I've just, in the slide, put here our purpose: to protect and promote human rights and equality in Ireland and build a culture of respect for human rights, equality and also intercultural understanding in the state. And I'm just flagging that there in terms of the public bodies within Ireland. IREC is the one which has a statutory mandate around interculturalism, which the Commission in our current strategy has also expanded into looking at the whole area of combating racism as well. And this is our set of commissioners that we have at the moment. I also wanted to give you a sort of sense of the scope of the work that we do. So when we're talking about mobilising the functions and the powers and the resource of IREC as a national human rights institution, these are all the domains of activity that we're engaged in. So it's a very broad brief and a very committed, passionate group of commissioners, but also of staff as well. In my team, I'm responsible for research and data, international reporting, legislation, public policy analysis. And in that I would flag public policy or legislative review and reform. So we're not just responding to legislation coming through from the state or from private members' bills, but we're also looking at areas in which there needs to be legislative reform. And so to go forward then, I just wanted to give a couple of examples of some of the casework that IREC has done in terms of the rights to family life. This one here are two cases that we took together to the Supreme Court in Ireland. And I think it's useful in terms of the issues around permission to remain. But in our submissions to the Supreme Court, we mobilised the right to private and family life, guaranteed in our constitution. Ireland has a written constitution, and also the European Convention on Human Rights. And what we're finding is a very positive engagement with the superior courts in Ireland, and a valuing of the contribution that IREC gives in terms of our legal expertise and insights. And in this context, the Supreme Court found that there had been a duty on the Minister to consider the family's right to privacy and family life in deciding whether or not they would renew or vary the permission of the families concerned to be in the state. This is one of the families, for example, was there because they were engaged in study in the state. But also specifically, they found that the Minister had acted unlawfully in requiring families to either leave the state or have their status moved into a situation of illegality. So I would say, in terms of the work on our legal casework, the power of being an amicus curiae and providing advice and legal submissions to the superior courts is a really important strategic intervention that we can do in an area of law. And similarly then in family reunification, this is still an ongoing case, but we have been given permission by the Court of Appeal to act as amicus curiae. And this is in, as I say, on World Refugee Day. This is a situation in which families were refused family reunification because they had moved from having they had had their refugee status granted, and because they were naturalised as Irish citizens, the state decided that they no longer had an entitlement to family reunification, and that's something that we're obviously contesting through the courts at the moment. I think with this, and then also some of the areas I'm going to talk about around policy and legislation, I think there's an opportunity to consider in terms of solidarity the other experiences of rights to family life that other rights holders are living through. But I think it's also to look at interventions that national human rights institutions do around particular issues to do with family life and how those can read across into just the experiences of disability rights holders. And so I'm going to talk about in 2018, IREC produced a policy statement around the right to family reunification. But one of the things I wanted to highlight in that, very comprehensive policy statement was that it brought together a lot of the domestic constitutional legislation, but it also drew on the European Convention on Human Rights. So they're quite useful resources, these policy statements that come out from NHRIs in terms of what is the legal context in Ireland, what can be mobilised to protect and respect and promote rights holders' right to family life. And in this was a key moment for IREC in terms of using human rights standards to take a wide view of what actually constitutes a family. And that has been part of the discussion today about how do we define our families in Ireland. I also wanted to then talk about another policy statement we brought out in 2017, again around something that's not around disability rights, but is about the provision of emergency accommodation to families experiencing homelessness. And yet I think this is a really critical area of public procurement of services, particularly in Ireland, where a very high percentage of disability services are actually procured from third parties by the state. And in this policy statement, we took a position that service level agreements need to include commitments to human rights and equality, and also, as relevant, include references to family life, autonomy and privacy. So although this is an area in which IREC has intervened through a policy statement around homelessness, you can sort of see within the disability community this is a very important position for the National Human Rights Institution to take in the context of the procurement of disability services and other services used by persons with disabilities. Then I want to talk about a piece of legislative observation that we did around the Children and Family Relationships Bill in 2015. And this, I think, is an example of how IREC, as a national human rights institution, mobilised its statutory function to align domestic legislation with rights to family life as elaborated in Article 8 of the European Convention on Human Rights. And I think we play a very important role, both in terms of communicating the experience of rights holders into the international realm, but then also drawing that back down in a domestic sphere in terms of legislation, in terms of policy, and also in terms of practice, and as I sort of said, around areas like procurement. And again, I think there's much in this that talks to the experiences of rights holders who have disabilities in terms of right to information about one's own identity, enjoyment of relationships in so-called non-traditional family situations, recognition of sibling relationships, and also recognition of family life, regardless of whatever the parents' living arrangements are. So I think, again, these are just resources that I think it's really important that the National Human Rights Institution creates and then develops with different groups of rights holders. And then just finally, another piece that we did in 2014 around direct provision, and I'm conscious of time, so I'll not go into a lot of the detail of this, but this is an interesting example of where we have drawn together an evidence base around citing the views of international actors who've expressed concern about the situation in Ireland. We've also looked at the various instruments which Ireland has either signed or ratified, and often there's, as we know with the CRPD, there's often a big delay between signature and ratification. We've then used our expertise to provide a commentary around how those international standards on family life relate to a situation around direct provision, which is for people in the international protection system in Ireland. And then we've taken a view that can be quoted and cited in all sorts of different ways once ARIC has mobilised the authority of the National Human Rights Institution to take a view on a particular issue. So then just to sort of talk a little bit about the work that we're currently doing on disability. As I said, we were established in 2014, so we're still a relatively new organisation, but we've published a new strategy in January this year, which is very impact focused. I think that's a really strong message that comes from our commission in terms of what difference does IREC make in terms of the everyday lives of persons in the state. And the Commission has chosen 4 different areas as cross-cutting priorities, and one of those is disability. And so therefore, in terms of the work that we're doing across all the different areas of activity I described earlier, disability is a core strategic focus across everything that we do. But I just want to sort of maybe end with talking a little bit about some of the specific things we do. We're the designated independent monitoring mechanism under Article 33 2, although that legislation is still going through our Parliament. The approach that IREC has taken in terms of initiating that work as the independent monitoring mechanism is very much to focus on the whole area of participation. And in some ways, well, not in some ways, it's very much informed by some research that we commissioned from the Centre for Disability Law and Policy in Galway, where there was a recognition that actually there aren't very many DPOs in Ireland, but there's certainly not a pan-disability DPO. And in terms of the realisation of rights under CRPD, that's a really critical piece around how do rights holders actually participate in our own monitoring role, but also in terms of what the state does more broadly around the implementation of CRPD. And so a lot of the work we've been focusing on is around the state's obligations under 4.3 of the Convention, and the obligations both for us as the independent monitoring mechanism, but also the state under Article 33.3, and then the General Comment 7 as well on participation. One of the things that we've done, and this is very much with recognition to our colleagues in other NHRIs, has been to establish a disability advisory committee, and the first one of those was appointed in January and then will roll for the 3 years of our strategic period. We also have funded a disability visibility research network, and Eleanor Flynn is the principal investigator on that, so that will operate this year as an all-island research network. And tomorrow we are launching a campaign called All Equal, All Human, which brings together the voices of quite a diverse group of persons with disabilities in terms of what their experiences are of living in Ireland and participating within Irish society. And amongst that group, we have 3 members of our Disability Advisory Committee have generously contributed to the campaign. So that will be using the hashtag All Human, All Equal. This is our Disability Advisory Committee. I'm delighted we not only have a commission member, but we also have John Bosco in the room. John Bosco Conema, who's a member of the Disability Advisory Committee for, not for the deaf community, but is a member of the deaf community. And I just also wanted to include some examples of some of the information that we're starting to prepare around CRPD so that rights holders understand what it is involved, and also all actors and all members of Irish society understand what it involves. So we've developed an animation, and we've also done an interpreted explanation of CRPD article by article, and we also talk about the optional protocol because we think that's really important that we continue to state that Ireland chose not to ratify the optional protocol, but that's still very much on our agenda as the National Human Rights Institution. And then just finally, these are just some of the thematic areas I'm thinking about in terms of sharing learning, solidarity and activism between the LGBTQI community and the social movement and the disability movement. Some of these I've touched on in my presentation already, that idea of recognising and also protecting what we self-define as our family. promoting the visibility of our families. And it was one thing that struck me when I did the research around sexual orientation, is that some of the arguments used against protecting the family right to family life of parents who were lesbian, gay or bisexual was a disbelief that people already had children, and the children were also adults. They weren't just being born into the world. But that actual visibility of persons as parents and as families, providing a really sustained support both for family formation, and that animates the whole area of reproductive rights and legal recognition of family, but also for family relationships. And I think particularly where family relationships can be disrupted, one of the areas that we're looking at in the Commission is around where children may be moved out of the state for some kind of care situation, and now they're actually not living in the same country, and in our case often have a band of water between their family and the children. And it also talks, I think, in this, and I say this as a former social worker, about the need for training and professional development and a sensitised system of provision around family relationships. Promoting access to justice, because I think that has been a really important area in terms of the lack of access to legal representation, in terms of lack of access to advocacy, interpretation services, engaging with a justice system which isn't equipped in terms of training or guidance, isn't also necessarily receptive to the right to family life of persons with disabilities, and that being based maybe on discrimination. But certainly when I was doing research around the LGBTI community, very openly expressed hate towards members of that community within judicial settings. It's also around about delivering and procuring rights-based services. And again, in some of my research, children were identifying the importance of health services, education services and housing services as well. Looking at the importance of the community support that comes from other members of a social movement in a context where maybe the wider society is hostile or discriminatory, the value of having community support from one's own community. But then also trying to think about how do we support participation in community life for all family members of rights holders. One of the things obviously with the campaign that we're running, IREC is very minded about, is the whole quality of public discourse and how we can inform and shape and influence the public discourse in a positive way around human rights and equality. And then finally, I would say this, and it's an academic conference, so I hope it's warmly received, the importance of having really strong data and really strong research around the whole area of the right to family life. Thank you.
Thank you, Iris, for the overview of the role of IREC within the Irish context. And I want to introduce our next speaker, who is Valentin Aichele, and he's from Germany. He works within the German Institute for Human Rights since 2005, but he is head of the independent national monitoring mechanism in relation to compliance with the monitoring and compliance with the CRPD. And his expertise and interests are in the area of public international law, national human rights institutions, human rights action plans, poverty and social exclusion, non-discrimination, and in particular the right to education and the right to be equal before the law. So I'm going to hand you over to Valentin, who will talk about his role within the German Human Rights Institution.
Thank you. I had an interesting experience 2 weeks ago. An experience where the German Institute for Human Rights was somehow absent in important human rights events in Berlin. I was attending 2 film screenings in a private capacity. You might have heard of the first film, a documentary called Push, which provides an intense insight into the work of the UN Special Rapporteur on the right to adequate housing, Ms. Lailani Farah, and which explores the complex relationship of international investment and housing. Even though hundreds of thousands of people suffer from rising rents in Berlin these years, and even though it might be the most discussed topic in town, the screening was attended no more than 15 people. The second experience I had was at the screening of the film The Children of Utopia, which focuses on 6 20-year-olds who, at the age of primary level schooling, had attended an inclusive class of children both with and without disabilities. After both screenings, the organizers held talks with the audience. Much could be said about this. For instance, one could complain about the scant numbers of attendees at these films dealing with essential human rights issues. Further, in both cases, I experienced a lack of knowledge and awareness concerning human rights, in particular the rights and the perspectives of persons with disabilities. So, while in the former discussion, the perspective of persons with disabilities never was mentioned, in the later, there was not a single reference to the CRPD. Of course, this could happen everywhere, but what does it mean for a national human rights institution in terms of its activities and policies? Does this represent a failure of an institution that is to inform and educate the people on their rights and the rights of others? How could one define the role of a national human rights institution in such cases, given that these are tasked with bringing rights home, as it was said, and which is the topic of today's panel? But before I discuss these topics, I firstly want to introduce myself and welcome you all. My name is Valentin. I want to underline that it's my sincere pleasure once again to address you, the summer school attendees at this 11th International Disability Law Summer School at the Center of Disability Law and Policy at the National University of Ireland in Galway. So I have a number of slides, and the first slide that is up there is the title of the presentation, Bringing Human Rights Home, the Role of National Human Rights in Supporting the Rights to Family Life, the Example of Germany. I'm turning the slide now to the overview, which shows you the structure of my brief presentation. Under section A, I provide you with some facts relating to national human rights institutions, in addition to what was introduced just by my previous speakers. And under B, the German Institute for Human Rights at Work, the case of intersex people, my focus on this presentation, and under C, I want to close with some remarks. A, some facts relating to national human rights institutions. On this picture that is up on the screen, you see a large, lively group of people in Geneva in a conference room at the Palais des Nations. The former High Commissioner for Human Rights is placed at the center of the group. They are posing for a photograph capturing the moment of the 25th anniversary of the Paris Principles. That was in 2018. National human rights institutions are a special type of institution. They neither belong to governments nor to civil society. Their common ground is the Paris Principles, an international standard adopted by the UN General Assembly in 1993. Accordingly, national human rights institutions are tasked with promoting and protecting human rights. They should claim a broad human rights mandate, which should be set forth in constitutional and legislative text. In terms of their composition, they should be pluralistic, and they should be able to function independently as an institution. Certainly, independence is written in the very DNA of a national human rights institution. The responsibility, which differ from institution to one another, should include information and human rights education, examining legislation or review, doing human rights research and inquiring into human rights violations, publishing opinions, recommendations, proposals, and reports, work with the media, cooperate with UN bodies and national entities and actors such as civil society organizations. Some say national human rights institutions are no good. They are too balanced in their opinion. Some further criticize them. They are not independent. They shy away. They don't really help in solving burning human rights issues. These statements might all be true, at least in some cases. Certainly, we need to watch every national human rights institution. I mean this as an appeal to you in whatever role you may act, for instance, as a researcher, as an activist, or even staff member. However, the Committee on the Rights of Persons with Disability believes that national human rights institutions, and the committee has developed special bonds with them. And this is my next slide. The slide shows a picture, a photograph of a meeting held between national human rights institutions and the CRPD committee in February 2018 in Geneva. We discussed the use of indicators, in particular in relation to Article 19. Such meetings of national human rights institutions and the CRPD committee is supposed to take place once a year. When the Convention on the Rights of Persons with Disability was adopted by the General Assembly, many national human rights institutions had not had in-depth experiences in working on the rights of persons with disabilities. This has since changed. I would like to take the opportunity to inform you of the outcomes of a survey among national human rights institutions we conducted in 2017 and which was published last year. The relevant slide shows the cover of the printed edition of the study, which is titled Promote, Protect and Monitor, the 2017 update survey on Article 33.2 of the CRPD. What did we find out? We discovered that there is a trend towards increasing the number of national human rights institutions in charge of promoting, protecting, and monitoring the rights of persons with disabilities under the CRPD. We asked national human rights institutions for information on the role under Article 33.2 if they were designated to monitor the CRPD. The replies were 32% of national human rights institutions hold the sole responsibility for promotion, protecting, and monitoring the CRPD. 34% of national human rights institutions share the responsibility with other entities. Only 13% of the responding institution indicated that an institution other than the national human rights institution was responsible, and in 21% of the cases of the responding institutions, it was indicated that the state party had not taken a decision yet. One could conclude that the original idea of the CRPD's framers, who had national human rights institutions in mind when they negotiated in New York the wording of Article 33, is becoming an institutional reality. Section B, the German Institute at Work, the case of intersex people. In terms of the rights of persons with disabilities to family life, the German Institute for Human Rights has developed various activities over the years. However, our access to this has been somewhat contingent or reactive and is much less systemic, although these are, of course, issues that are so important to many persons with disabilities. For example, just this year, we had a press release on International Women's Day on the 8th of March, focusing on the rights of women with disabilities and the issue of intersexual discrimination and family life. In 2017, in our library, we also organized a reading from a book in easy language. And the book was on parental life of a couple in which both had a disability. Another occasion was in 2014 when we reviewed a state law providing funding for sign interpreters for parents in the context of school communication. Just to give you a few examples. Now I'm turning to the main subject, which is intersex people. Regarding the rights to intersex persons, the German Institute for Human Rights has also developed and in due course touched upon the various activities that a new national human rights institution might experience. Intersex, that needs to be said, is not an impairment. Intersex is not a disability. There is no obvious connection between intersex persons and disability. There is, however, an indirect one. Intersex persons, often in an early stage of their life, are subject to surgery. If these surgeries are performed without the free and informed consent of the person concerned, it is a human rights violation. Moreover, these surgeries often result in severe bodily and physical, psychological impairments, and in consequence might be the root cause for what we understand as disabilities. For example, if the persons concerned find him or herself in the wrong sex or gender, they are restricted practically in their choice of partner, and they cannot marry the person they wish. Or they might experience incredible pains, for instance, when having sex. Or they often lose their reproductive ability due to their surgeries, and they cannot have children. These are some of the severe consequences in relation to family life of persons with intersex gender. What we did, the German Institute for Human Rights encountered the human rights issues around intersex persons about 2007. It was hardly a known topic in Germany at that time. In 2009, we published a collection of essays on sexual self-determination as a human right, one of which was written by a colleague of mine after a long research, and it dealt with the rights of intersex persons. The next stage of that process was to report to the UN on these issues. I'm displaying a picture now. The current slides shows my colleagues Britta, Leander, and myself on March 26, 2015, in a session during which the CRPD committee had a constructive dialogue with the German delegation. We gave an oral statement at the beginning and at the end of the review session. Subsequently to our engaging in the issue, we, the National Independent Monitoring Mechanism, raised the issue of the rights of intersexual children in the parallel report we submitted to the CRPD committee in 2015. From its documents, it was clear that the CRPD committee had not dealt with the issue before. Nevertheless, we reported to the CRPD committee that there are, quote, estimated 80,000 to 120,000 intersexual people living in Germany. About 150 to 340 people a year are born with a gender that is not clearly female or male. Further, we informed the CRPD committee that, quote, in Germany, parents and guardians can still decide whether their child should be subjected to gender determinative surgical procedures, Studies and surveys have shown that this highly controversial practice of performing gender-determinative surgical procedures and treatment of intersex children without the children's consent and usually before they reach the school age exists in Germany. And consequently, we suggested the committee that the CRPD committee recommended that the state party, the federal government of Germany, prohibits the practice of irreversible, non-life-saving gender discrimination by means of a surgical procedure or treatment prior to reaching the age of maturity. The CRPD committee took up the issue in a dialogue, and the issue was also taken up in the concluding observations. Under the heading of Article 17 of the CRPD committee linked the issue to the concluding observations that the UN Committee Against Torture, CAT, had made regarding Germany earlier, which was 2011. Submitting amicus curiae briefs. Now, the story of our work on intersex people in Germany leads us to the German Federal Constitutional Court, and this bit shows and draws the attention to the activity of a national human rights institution producing amicus briefs. And I'm having another slide with a picture on it, which shows the main courtroom of the German Federal Constitutional Court at Karlsruhe. It is a very transparent room, and no person can be seen in the photograph. It is in 2016, so 1 year after the concluding observations of the CRPD committee, that the Federal Constitutional Courts in Germany received a complaint from an individual who requested registration as diverse/inter. The authorities had rejected this on the basis of the then valid law, the law on the civil state of a person, and this rejection was approved by the courts as the law only knew male and female. Thus, the constitutional issue before the German Federal Constitutional Court was whether the person's general right to personality was infringed upon if there was no other choice than male and female. At the request of the court, the German Institute for Human Rights submitted an amicus curiae brief on the matter. And in October 2017, the court took a decision which is truly groundbreaking. It decided that the law was unconstitutional on the basis of the person's constitutional rights, the general right to personal right and the right to equality. And this was groundbreaking, not in terms of the acknowledgement of a third sex, but as the court requested a law providing options for someone who does not fit within the binary framework of male and female. However, the court's ruling is not enough. The legislator needed to enact an appropriate law. This is the next chapter of the story in which the German Institute for Human Rights played its role. For illustrating this, I'm putting up a peculiar picture of the German Bundestag, the location of the legislature in Germany, which is the Reichstag building on a very bright day. You cannot see the building as Christo and Jean-Claude, two artists, have wrapped it up. You can only see the covering. The Reichstag looks a bit like a big parcel. It also looks like a bit scary. In front of the building, you can see many people. In the draft law for the third gender option was discussed in 2018, the German Institute for Human Rights submitted a statement and took also part in the parliamentary hearing as an expert witness. Now, to cut the story short, the law in Germany is changed. German law now recognizes the third option as diverse. However, this third option does not prohibit the practice of irreversible, non-life-saving gender determination by means of surgical procedures without free and informed consent, to the person concerned. Thus, we, the German Institute for Human Rights, have increased our energies aimed at encouraging politicians to put a stop to this. And so, in this case of the rights of intersexual persons, the story will continue. In kind of conclusion, should you remember where we're at? This is 13 years after we started researching on the issue, 11 years after we had published a book on the subject, 8 years after CAT adopted its recommendation on Germany, 4 years after we had reported to the CRPD committee, which confirmed the need to action, 3 years after the complaint was filed with the Constitutional Court, 2 years after the court delivered its judgment, 1 year after the law was discussed in Parliament, and just a few weeks ago, which was the 12th of April, the law came into force with the third gender option. What we may learn from these activities in relation to family life of a national human rights institution, they are interconnected and they may be seen and understood as a process work. Doing research and investigation, interacting with UN bodies, particularly with treaty bodies, finding ways of obtaining judicial advice and judicial decisions, advocating for human rights policy solutions, commenting on draft laws, and overall informing the public and others, all this might go hand in hand. I'm seeing the sign and I just want to share my closing remarks with you, which are a bit rather weird. First, the rights of intersex persons represent a severely neglected human rights issue. It is indirectly linked with disabilities and tightly interwoven with the right to family life. Secondly, national human rights institutions cannot take up every issue and they cannot be everywhere at once. And national human rights institutions nevertheless should be aware of all pressing issues and find ways to deal with them. Thirdly, a growing number of national human rights institutions are being asked, with monitoring the CRPD, the various types of activities to promote, protect, and monitor human rights might be interconnected and can be seen as a process. And last but not least, if a national human rights institutions is to bring rights home, including the rights to family life of persons with disabilities, then it often must be prepared for the long haul. I thank you for your attention. Please.
Thank you, Valentin. Our next speaker is Elizabeth Kamundia. She is from Kenya and she works with the Human Rights Institute in Kenya. Elizabeth is also an alumni of the LLM in International and Comparative Disability Law and Policy, the educational program here at the Centre for Disability Law and Policy. So I'm going to hand you over to Elizabeth, who'll take you through Kenya's situation.
Thank you, Katrina. I'm really pleased to have the chance to address you once again, this time speaking about our role as the Kenya National Commission on Human Rights in protecting and promoting human rights and specifically the rights of people with disabilities. So I work at the Commission. I lead the Commission's work on matters of persons with disabilities. And I'd just like to begin with an outline in terms of what I'd like us to focus on today. I'll introduce the Commission so you get a sense of the numbers and our specific mandate. I'll also speak very specifically to the functions of the Commission that relate to the right to family life. So my colleagues who spoke before me identified certain roles that national human rights institutions take. So I'll just focus on the ones that we've worked in relation to the right to family life, which include our functions in terms of complaints and investigations, our functions in redressing human rights violations, our work in terms of ensuring compliance with obligations under international and regional treaties, all of which is done in an effort to promote the respect for human rights. So in terms of an introduction to our commission, the commission is established under the Constitution, Article 59, but this article establishes 3 different commissions. So there's the Kenya National Commission on Human Rights with the mandate of protecting and promoting human rights, and it's the National Human Rights Institution. But we also have the National Gender and Equality Commission, which is charged with the equality and non-discrimination mandate, where in the Irish context it's a merged commission. And then we have the Commission on Administrative Justice, which is the Ombudsman, which is charged with dealing with maladministration issues. So those are the 3 commissions that work, in collaboration with each other. Our commission is an accredited A status National Human Rights Institution by the Global Alliance of National Human Rights Institutions, which gauges NHRIs on various categories, with independence being one of the most important. We are up for reaccreditation again this year in October. We also have affiliate status with the African Commission on Human and People's Rights, which enables us to go before the African Commission and speak in the public sessions of the Commission. We are also required to submit a report on the status of human rights in the Republic every 2 years to the African Commission. So this is in relation to our affiliate status. We've also been designated as the monitoring agency under Article 33(2) of the Convention, similar to the commissions represented herein. And in terms of staff, we have 4 commissioners. We have about 115 staff members and 40 interns and attaches distributed over 5 regional offices in various parts of Kenya. So that's basically the size of our commission. So in relation then to our work on family life, I have a slide here that relates to our mandate in terms of complaints and investigations. And what I did was, basically we have a complaints management system because we have members of the public coming into the commission to complain about various human rights violations. So we extracted then from the database complaints that we've received that are related to disability. So either complaints brought, most of which have been brought by persons with disabilities, or on behalf of someone with a disability. And I just looked at these complaints as between January 2016 and 30th of December 2018, so 3 years. And we've received 34 out of a total of 30,274 complaints. Only 34 of these are from persons with disabilities. That's about 0.11% of the complaints. In terms of the sex of the complainants, the majority are male, about 27 men and 7 women, and there is no intersex person with a disability who's made a complaint to the commission. In terms of the kinds of complaints, so the subject matter of the complaints, most of these complaints, 11 of them, which is about 32% of the whole, are complaints that are related to social assistance. So for those of you who are here when we spoke earlier about independent living, and we were talking about questions of state support from the state in terms of grants and the lack of information. So many of the complaints relate to people with disabilities coming to the commission and saying, look, I've registered with the National Council for Persons with Disabilities, but I'm not receiving any support, financial support or bursaries or the monthly stipend that Fatma referred to yesterday, that is $20 for persons with severe disabilities. So either there's clearly a lack of information about what you have to do basically in order to be registered, and what you have to do in order to meet the criteria of the severity in the language of the program in order to be eligible for a grant. So most of them are related to social assistance, but we also have received complaints in terms of labor rights, discrimination mostly in employment. We've received complaints related to the right to housing, political participation, and other areas, but I just selected the top 4 kinds of complaints to give you a sense of the issues that people with disabilities are, facing violations in. In terms of complaints that are directly related to family life, only 2 of these complaints are, and it's in relation to, in one case, dispossession of property. So someone with a disability, the uncle has taken over their land and, comes to the commission to make a complaint in relation to this. And the other case is in relation to a woman who is deaf, who whose partner is refusing to pay child support. But I think what you will note, and in terms of the cases that we have admitted that have met our admissibility criteria, of all these 34 cases, only 6 cases are cases that we can deal with as a commission. So most of these cases are about referring people with disabilities to the respective offices that may solve the complaints that they have. And a lot of this is about failures in other bodies to either pass information or just government services not, being very effectively delivered in some ways, so that most of the complaints we are receiving are about things which, in a system that works well, wouldn't be coming, to the commission. But people know about the commission, and so they come and get information from us. In terms of complaints that are related to sexual orientation, gender identity, and sex characteristics, between January 2016, so the same time period, we had 0 complaints in this regard, right? And which is concerning, because at the same time we've had a report from an NGO called Kenya Human Rights Commission, very similar to the name of the NHRI, where they've documented many cases of people being subjected to attacks, but for some reason they're not seeing the commission as a place, they hadn't been, prior to this, seeing the commission as a place to make the complaints, maybe because of lack of information about the commission or for other reasons. But so I looked then into the data for this year, the 6 months so far, and we've received 2 complaints related to sexual orientation, one from a transgender woman, and in relation to the ones on intersex persons, I'll speak to that because there's quite a number. There's 29 of them, so I'll explain how that is in a short while. But just to say that the commission is part of a project which explains the rising numbers, the 3 cases in a span of 6 months when there was nothing before. We are part of a project being run by the national NANRI, the Network of African Human Rights Institutions, which is happening in a number of African countries: Kenya, Uganda, Malawi, South Africa, and Ghana. And the role of the purpose of this project is to strengthen the capacity of NHRIs to address matters related to sexual orientation, gender identity, and sex characteristics. So as a result of this project, then there has been a lot more updates in our social media pages about this, just a lot more information that we are interested in doing this work. So that's the reason, and in a short while I'll speak about the intersex part of it. But so now I'm moving on from the complaints section of the work to our work on redressing human rights violations, right? So in terms of redressing human rights violations, as a commission, we have the legal possibility to go to court either on our own on our own motion or on behalf of a group, or as amicus curiae similar to the Irish Commission, or as interested parties. So earlier today we had the happy story of Botswana and decriminalization. I am not the bearer of good news in that on the 24th of May, just this year, our court, our High Court, passed over an important opportunity to decriminalize. So we did not decriminalize, but let me speak a bit more about the facts of the case. So our Section 162 and 165 of the Penal Code criminalize same-sex conduct, and in the terms of the law, it's termed as an individual, so an unnatural offense where an individual has carnal knowledge against the order of nature, and this is a felony, and there's a sentence of up to 14 years imprisonment, right? So this case was brought not on the issue of same-sex marriage, but on the issue of decriminalizing these provisions. And as a commission, we were amicus curiae in this case, where we were arguing that it's discriminatory, that these provisions are discriminatory. We were also arguing that they violate the right to privacy and dignity, and quite, and were giving cases to this effect, borrowed from the Indian jurisdiction as well as other jurisdictions that have decriminalized before us. However, the court stated that Article 45(2) of the Constitution, which states that every adult has the right to marry a person of the opposite sex based on the free consent of the parties. So that's Article 45(2). So the court stated that this article only recognizes marriage between adult persons of the opposite sex. In our view, decriminalizing same-sex on grounds that it is consensual and is done in private between adults would contradict the express provisions of Article 45(2). The petitioner's argument that they are not seeking to be allowed to enter same-sex marriage is, in our view, immaterial, given that if allowed, it will lead to same-sex persons living together as couples. Such relationships, whether in private or not, formal or not, would be in violation of the tenor and spirit of the Constitution. So, sadly, that's how that went. To perhaps happier case, better outcome case, is the Baby A case, which again the commission was involved, this time as an interested party. In this case, a child was born, an intersex child was born in 2009, May 2009, and in the birth registration document, they couldn't, usually there's a sex marker, FM, and they put a question mark because they couldn't tell at that stage the sex of the child. And as at the time the case was brought to court, which was in the year 2013, this child had not yet been issued with a certificate of birth, a conclusive certificate of birth with full details, and so there was argument then that the right to dignity was the child's right to dignity was infringed, as well as being denied the right to recognition as a person, legal recognition. The court held in this case, and Kensechar was part of amicus and played the role of bringing to the court the facts of, information about who an intersex person is, information about that it's a violation of human rights to conduct surgeries, just information about the human rights elements of the case. And in this case, the court stated that, to my mind, the fact that an intersex person, as defined elsewhere above, does not fall within the definite criterion as being distinctively male or female should not negate his right as a human being, in whom rights and freedoms are inherent. The fact that the Births and Death Registration Acts and the Constitution do not define the term sex does not mean that we should hide behind the traditional definition as we know it, right? So, and as a result of this case then, the Attorney General established the task force on policy, legal, institutional, and administrative reforms regarding intersex persons in Kenya. So a task force was put in place, and this commission, the Commission on the KNCHR, was part of that task force, which completed its work late last year. The task force mandate was to compile comprehensive data regarding the number, distribution, and challenges of intersex persons. The task force also had the mandate to examine the existing policy framework, institutional, legislative systems governing intersex persons, and to recommend comprehensive reforms to safeguard the interests of intersex persons. So as part of this work then, interviews were conducted, including 112 key informants were interviewed, either people who are like parents, siblings in close proximity to intersex persons. 40 intersex persons were interviewed directly, and there were further analysis shows that the data captured 58 minors and 54 adults. And the key findings in relation to human rights violations are that there is gross violations related to health, including these questions of the botched surgeries that Valentin pointed to earlier. There's that also going on. There were really sort of sad stories from parents who've sold everything to do these surgeries, and still it doesn't fix what they thought they wanted, to fix. And so these are some of the violations. Just people who are intersex facing violence within the community, being expelled from schools, particularly at puberty once, their sex characteristics are discovered, denial of registration as had happened in Baby A's case, problems with employment, social protection, basically violations cutting across nearly all human rights. But as a result of this, the report that was produced by this task force, in which KNCHR was also a member, the Kenya National Bureau of Statistics will include a sex marker that is other in this year's census. So we are having a census in August of this year, and for the first time in the history of our country, we will have a marker that is beyond, the binary that has been there before. And now the task force, the earlier task force mandate came to an end last year when they presented the report. But now there's another one for implementation, right? And the Commission is chairing this particular implementational task force whose work commences actually this month, earlier this month. So there's work going on in this regard. So I will say just one thing in relation to the third mandate, in which the Commission does work related to family rights, right? So we've looked at our work in complaints and investigations, our work in redressing human rights violations, going to court, and now something about what we've done in relation to compliance with obligations under international and regional treaties. So in a sense, Kenya is coming before is undergoing its third cycle of the Universal Periodic Review. We are due for review in January 2020. And as a commission, we are supporting the disability cluster. So usually we have a CSO, civil society stakeholder report under Universal Periodic Review. So the commission is specifically supporting the disability cluster within this CSO's report. And the right to marry is one of the key recommendations that we are making, and in particular, the recommendation to repeal Section 73 and Section 66, which allow for the annulment and divorce on grounds of insanity. So just to end with a plea, if your country will be one of those, with the opportunity to make a remark to Kenya, through this universal periodic review process, please make the remark on repealing, the recommendation, not the remark, the recommendation on repealing sections 73 and 66 of the Marriage Act. Thank you very much.
Thank you, Elizabeth. We have about 10 minutes for questions and answers. So I'm going to open it